Hi there, I'm Savannah Mexto with Mannor Law Group, and I'm excited to welcome you to another Webinar Wednesday with esteemed elder law and estate planning attorney, Robert Mannor. Today's webinar will talk about the things that are often not talked about, the reasons why you may not even realize you need an estate plan. You never know unless you know. Now, if you truly want to protect and preserve the future of those you love most, this is the webinar for you. Before I pass the torch to Bob, I'd like to cover a few housekeeping details. First, a disclaimer. Today's webinar will be educational, informative. You'll definitely learn something, but you're not going to get unique legal advice for your situation. I encourage you, if you are looking for legal advice, to contact us after the webinar. Also note that today's webinar is recorded. If for some reason you get pulled away, it's okay. I will send out a replay link tomorrow afternoon, and you can share that link with family, friends, or coworkers. Now, if you have questions today during the webinar, I encourage you to put your questions in the chat box. We'll save time at the end of the webinar to review those questions. If for some reason we don't get to your questions, we will contact you after the webinar. Now, why should you listen to what the folks at Mannor Law Group have to say? First, note that we're a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Mannor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. He's currently on the executive board of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. Lastly, Mannor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd like to welcome Attorney Bob Mannor.
Hi, folks. How you doing today? So this is an interesting and fun one. We're just going to kind of get right into it and talk about the different reasons. Now, just to be real about this, everybody kind of needs an estate plan. And so I know a lot of people think that, well, my situation is simple, or I really don't need anything overly complicated. And that's one of the goals, right? We want it to not be complicated for our family. But there are some unique situations where people haven't really always thought through all the consequences of the unique situations, and frankly, they're not all that unique. So I start off with the Brady Bunch here, right? The blended family, his kids and her kids. And this is particularly important because a lot of folks, they'll have wills, and they'll just not have any plan whatsoever, and haven't really thought it through, and they just assume that things are going to go the right way. And this is almost always a recipe for disaster. That it's not going to go. Often it causes all kinds of fighting and difficulty in the family, but often it was not intended by anyone. So, we often hear the trope about the wicked stepmother or the bad stepfather, and often, I see this so often that kids are cut out of the estate unintentionally, and I don't think it was anybody's intention to cut the children out of the estate. So let's imagine we have a family, and husband and wife, and they got married, and he had kids before the marriage, and she had kids before the marriage, and what do? Well, they buy a house together. Okay, so great. Well, they had he has a will and she has a will, or maybe they don't have anything. What's going to happen with that house? Well, when the first person dies, they bought a house together. So when the first spouse dies, let's say it's the husband, everything gets left to the wife. So what happens when the wife dies? Everything goes to her kids. Or what if it was the wife that died first? Everything goes to the husband. And when the husband then dies, everything goes to the husband's kids. And so we've left out half the family, probably unintentionally. But worse, we kind of let it go to chance. We're kind of rolling the dice. Whoever dies first, they lose. Whoever lives longest, their family wins. And that doesn't make a lot of sense, right? And so we really have to, it's particularly important to do real thorough planning. And this is actually one of the big reasons to have a trust. There's lots of reasons to consider doing a trust, which is basically a contract saying how you want things to be handled during your lifetime and after your death. But one of the big ones, of course, is going to be the blended family, so that we don't have a situation where one side of the family gets completely cut out. And it's not just about the house. So what we often will have, so think about this. I see this at least once a week, often more than once a week. It is extremely common. So we have a family that comes in, and we have his kids and her kids, and they have IRAs or they have an investment account. And so they may have even kept their assets separate. So a lot of times with the blended family, he keeps his assets separate than hers, and so she has assets and he has assets. But who do they list as the beneficiary? Well, they want to take care of their spouse, right? So they'll often list their spouse as the beneficiary. They say, well, that's okay, no problem, because I've listed contingent beneficiaries. And the contingent beneficiaries, he's listed his kids and she's listed her kids on her as her contingent beneficiary. Okay, here's where the problem is. They're not going to die at the same time, right? Most likely, one of them is going to die, leave everything to the surviving spouse. And then that spouse has their contingent beneficiary as their kids. So even though he thinks that, okay, I have my spouse because I want to take care of her, but then I've got my kids as the contingent. So the kids are ultimately going to get whatever my spouse doesn't need. That's not going to happen at all. In fact, everything's going to go to the spouse. It's going to roll over to the spouse. And now the spouse is going to leave everything to their kids because that's how they had set up their contingent beneficiaries. So, we think about this and we don't think about the order of things, right? So people will just say, well, I have beneficiaries, that should be sufficient. I've listed my spouse, I've listed my kids. No, you haven't listed your kids if you die first. If you die first, you've listed your spouse, and then your spouse listed her kids or his kids. And so now we've lost now one side gets everything. One of the things I commonly see is a family, a married couple, they got married maybe later in life, and by later in life, meaning they already had their kids. So, and sometimes it's, older, sometimes it's not that old, but the bottom line is when it's a second marriage or something like that, it's more common for people to have a prenuptial agreement. And so they'll have this prenuptial agreement that will say what will happen when one of them dies, what will happen, if they got divorced, all those types of things. But the bottom line is what happens we see, people before they got married, they got a prenuptial agreement, they did their estate planning, they did all these things, and then time goes by. And what do people tend to do when they're married as time goes by? Oh, well, I love my spouse. Let's buy a house together. Okay, great. Well, we have a house together. Now we need to have a bank account together to maintain the house. Oh, well, I want to make sure my spouse is taken care of, so I'm going to list them on my IRA as the beneficiary. I'm going to list them on the investment as the beneficiary. Guess what? You've just deleted your prenuptial agreement. The prenuptial agreement only works if we keep the assets separate and don't have the spouse listed as the beneficiary. But that's not what usually happens. I have people come in all the time. They have a prenuptial agreement that's not worth the paper that's written on, because once you commingle the assets, the commingling of the assets or the beneficiary designation is going to take precedent over the beneficiary designation or even the trust. If we commingle assets and we have a trust, but we don't put the assets in the trust, or if we commingle assets and we put a beneficiary designation, we don't list the trust isn't going to work. The beneficiary designations are going to take precedent over that. The prenuptial agreement's not going to work. So it's really important that we come together as a family and we say, okay, here's what we want. Sometimes we have a situation where we say we want to leave everything to the surviving spouse, and then we want everything to the 6 kids, his 3 kids and her 3 kids. Okay, well, maybe we need to be able to set that out and come to an agreement and set that out so that it's divided. Now, what if it was 4 or 2? He has 4 and she has 2. Okay, well, does that mean that it's still divided 6 ways? Or does it mean half of it goes to the 4 and half of it goes to the 2? That's something that you have to decide. What I often will see, or at least I occasionally see, people will come in and the husband has an idea of what they want and the wife has an idea of what they want, and they don't mix. And what I have to do, what my job is to say, okay, we've got to figure this out, because we can't just say, no, whatever's gonna, I'm gonna get everything when you die, but then I'm gonna leave it this way, and you're gonna leave it a different way. We got to come up with a joint agreement that says when we die, here's what's going to happen. And one of those possibilities is to say, okay, we've kept our assets separate. So husband's assets are going to go to husband's kids, and wife's assets are go to wife's kids. Problem with that sometimes is they say, but I'm worried about my spouse. What if they don't have enough money to live on for the rest of their life? So sometimes what we set it up is we have to set up a trust, but the idea would then be to say, all right, well, we're going to leave these assets to my spouse for their use, and whatever they need, they'll be able to use to make sure they're taken care of. But whatever's left over is going to go back to my kids, so that let's just use George and Sally. So George and Sally, George has some assets and Sally has some assets. George says, I want to make sure Sally's taken care of. She's the love of my life, but I've been married to her for 25 years. So George says, I want to make sure Sally's taken care of. And I said, well, how do you feel about Sally's kids? Well, I'm not always as fond of them as I am as my own kids, at least. And so are you okay with Sally's kids getting your assets in the event that Sally dies 10 minutes after you, or Sally dies a month or 2 months after you? No, I wouldn't like that at all. Okay. Well, it's possible to set it up so that George says, okay, we're going to leave everything to Sally. It's going to be in the form of a trust. Sally has access and use of it. But upon Sally's death, it's going to go back to George's kids, and vice versa for Sally's kids, if she kept her assets separate. So there's all of these different options, but as you can see, it's really important to lay this out. And the standard ways that people think that they can do it, using beneficiary designations or having their own wills, those don't work. Those will not work. Okay, what's the next one? Special needs or disabled child. This is really important also, in that if we have sometimes we think that that's fine. Of course, we want to take care of our special needs or disabled child, and so that they'll just inherit their portion of the estate just like any of the other children. Well, that can create a problem, because if they inherit money directly, they could lose their medical benefits, or they could lose their disability, right? And so we don't want to do that, depending on the type of disability that they're receiving or what kind of medical benefits they're receiving. Certainly, if they were special needs or disabled from birth, it's very likely that if you leave them assets, they will directly, without protecting them properly, they will lose their benefits. The other thing is, I've heard people say, and this is very common, and even, they went to a lawyer and the lawyer said, well, you're going to have to disinherit your daughter because she's special needs. No, that's not the answer. We don't have to disinherit your daughter. And sometimes people say, well, she's all taken care of because she gets disability. How much is that disability check? Is that really going to be enough? Oh, yeah, it's enough. Okay, great. Do you ever buy her clothes? Oh, yes, we buy her clothes every year. Do you ever provide, take her out to dinner? Did you take her on vacation? Did you ever do any of those types of things? Oh, yeah. Do you ever go by and get her some snacks? Oh, yes, we do all that. Well, who's going to do that when you're gone? Oh, yeah, I guess that would be nice to have some money set aside for those types of things, because the disability check doesn't really go very far, right? And so the idea is you absolutely do not have to disinherit your special needs or disabled child. It's a relatively straightforward process to make sure that that money, whatever you leave to them, whether it's an equal share or something else, or a greater share, depending on the needs of the person, is protected. And that it's not going to interfere with their medical benefits, not going to interfere with their disability. They can still maintain those benefits and get an equal share, or get whatever share of the estate that you would want them to get. We have to put somebody else in charge of it, right? So you might want to put one of the other kids in charge of it, or somebody else, brother, sister, niece, nephew, whoever it is that we trust to be in charge of that money. Your special needs child cannot be in charge of that and also receive disability or medical benefits. That's not going to be possible, unfortunately, depending on the type of disability, type of medical benefits. But so we put somebody else in charge of it. Let's say it's a sister or a professional, or sometimes there's even some groups that can assist with this, or trust companies, things like that. Often we want it to be have family members involved in that decision making, right? And so it's not a difficult process, but it is absolutely important to do this through your estate planning. Is it possible to protect those assets, protect that inheritance after you die? So you don't do estate planning, you have a special needs child, they're going to inherit a third of the estate. Is it possible that that could be protected? And the answer is maybe through a court or through what's called a first party special needs trust. But the bottom line is there's two problems with that. We lose some control over it, number one, and those are going to have what we call payback, meaning that whatever benefits that person received during their lifetime is going to have to be paid back with whatever's left over after they die. Whereas the types of planning that we're talking about, so if you have a special needs child, you want to leave them something, you can say, well, if there's anything left over when they're gone, it's going to go to my other kids, or it's going to go to whoever else that I want. It doesn't have that payback. So if you don't put that in place, that money is going to potentially go to the government. But if you put it in place, it's not going to go to the government. The money, whatever's left over, would go to your other relatives. So it's so important. This is just a no-brainer. If you have someone that's on SSI and Medicaid and something like that, we can't just leave them directly. We can't just leave them, and we don't want to disinherit them. That seems very wrong also. But we can easily, get that set up appropriately. All right. Next one, what if you have young children or young adults? Okay, these are two separate issues, right? But young children, well, one of the most important things is to say, well, if both mom and dad are gone, we need to specify who is going to raise those children. And who's going to raise those children might not be who we want to be in charge of the money that we leave to those children. It could be the same person, but it could be somebody different. We might say, boy, obviously I'd want my sister to raise the children. If both my spouse and I are gone, I'd want my sister to raise my children, but she can't balance her checkbook. And so I wouldn't want her to be in charge of the finances. If she gets her hands on money, she spends it as quickly as she can. I'd want somebody else to manage that money. So I'm going to have my, cousin do that, or whatever it is. The other issue is, what if you're divorced? So what if you're divorced and you say, well, obviously it's just going to be their other parent that would raise them. Yes, but if you have done planning that specifies who you would want to raise your children in the event that you're both gone, and they haven't, the judge is probably going to follow your wishes. And so sometimes that's important. So let's say we have a divorced couple, and the mom of the young children says, boy, I really wouldn't want his parents raising my kids. Then you better specify that in your legal documents and decide who's going to be their guardian, but also who's going to be in charge of the money. Because, the possibility exists that even if so you're divorced, and so mom says, okay, well, yes, it's perfectly okay for me to have their dad raise them, but I certainly don't want him in charge of the money. Well, if you don't have anything in place, guess who the most logical person would be for the court to be in charge of that money? It's going to be their dad. And so wouldn't you rather have it say, okay, yes, it's fine for him to raise them, and I want them to use whatever money I leave for their benefit, but I don't want them to have full control over it. I'd rather have my parents or my sister or somebody else in charge of the money and dole it out as appropriate and necessary. And if it's left over, give it to the kids directly when they get an appropriate age. But that's kind of the other issue here. Well, what if we don't have plans? Well, then there's going to be a court appointed. So there's going to be, if you leave kids money directly and they're under 18, they're going to have to typically get appointed what's called a conservator. So now the court is appointing a conservator to be in charge of that money, to monitor that money, and they turn 18. And guess what? On their 18th birthday, who now is in charge of that $200,000 life insurance policy? You got it. That 18-year-old who has his eye on that hot rod and buying fireworks for a party with his friends, and college. Yeah, he wants to go to college, but boy, we could spend that $200,000 a lot better than college. We typically don't want to put money in the hands of, large sums of money in the hands of an 18-year-old. And it's relative what would be considered a large sum of money for an 18-year-old. $10,000 probably is a large sum of money for an 18-year-old. Doesn't mean that we don't want them to have access to it, or that they couldn't use it for college or use it for, housing or schooling or whatever it is. But often the 18-year-old just doesn't have enough life experience or experience with money, at least that kind of sums of money, that we'd want to put it in their hands and have them have the absolute, decision-making authority over that. We want them to be a little bit older. Sometimes people say, oh, well, okay, not 18, well, let's go with 21. Perfectly fine age. But even 21-year-olds, do they have experience with money? Do they have any life experience? And it's not that we want to prevent them. We see these movies sometimes where you'll have these rich kids that have this trust fund and they can't get access to the trust fund, and this whole movie about this trust fund. That's not what we're talking about here, to the extent that we want the money to be available to them to go to school, to do, whatever, but have their aunt or their uncle or your brother, your sister, whoever it is, have somebody else have veto power or supervision of that money until they're an appropriate age, 25, 26, 30, whatever that age is. I think it depends on how you feel about that, and whether or not you want it to be where once they turn 21, they can do whatever they want with the money. But once they turn 25, they can do whatever they want with the money. Or you still want them to have some supervision until 25 or 26 or whatever age that is. But that's something that you should probably give some thought to, and that's what we do, is we help you think through all of these things. Okay, so that's when the young adult situation, So maybe you say, I'll have folks come in and they say, oh, well, we don't have any minor grandchildren. Well, there's two issues with that. Number one is, what if your children, both your children and grandchild pass away? Would we want to leave that money on to the next generation? What if there's great grandchildren and then they are going to be minors potentially? Or what if it's a 25-year-old that lives in their parents' basement and hasn't had a job yet and isn't looking for a job, and maybe is involved in some other things that giving them a bunch of money probably wouldn't help them. I had a case years ago where a gentleman came to see me, and his plan was written up by a different attorney, and the plan was irrevocable. Now, sometimes we do irrevocable, unchangeable is the word, irrevocable, unchangeable. Sometimes we do irrevocable plans, but we always make sure there's a way to change those unchangeable plans. So irrevocable, sometimes people say that means unchangeable. Well, it's not unchangeable. It's unchangeable to the person that created it, but we usually build in what's called a trust protector or something like that, so that if there are changing circumstances, the changes can still be made. The idea here, and what happened in this case, was this gentleman had a large life insurance policy, over $1 million, and he had two sons, and he was leaving it to his two sons, and he had it in this irrevocable trust because it was for tax purposes, actually, to make sure that they weren't going to pay taxes on it. And he found out he was terminal. And shortly after he found out that he was terminal and he was going to die, this was grandpa or dad, one of his sons died. And his son died, and his son only had one daughter, and she had just turned 18. And she was having a hard time her dad just died. She was having a hard time. She got involved in some drugs and things like that. And grandpa now was going to die. We kind of knew this. He was going to die soon. And the trust said, because the son had died and the son was going to get half of that $1 million, now that 18-year-old with a drug problem was going to get $500,000. Pretty much guaranteed that was going to kill that, 18-year-old with a drug problem. You give somebody with a drug problem $500,000, it's going to cause bad things. And there was no mechanism within the trust to change those terms. So we actually found a way. Sometimes we can get creative legally. We could have gone into court. There was actually a number of ways. Actually, I did a presentation about this, national presentation, oddly enough, to financial advisors and attorneys throughout the country through the National Business Institute. It was, how do you change an unchangeable trust? Is basically what it was. It was how to change any trust, but it was particularly focused on how to change irrevocable trusts. And so we found a way to do it and to fix that problem. But you can see why that would have been an issue. Right? Okay. Long-term care. So this is, we've been focusing on your beneficiaries for a while now, and it's important we also focus on you. So people don't think about their estate planning be about them. They think of it as being about, what happens when I die. But in our practice, very much as anything else, estate planning is about the rest of your life, not just what happens when you die, but what happens if you don't die. And what I mean by that is many of us, the majority of us, are going to face some period of time before our death that we're either physically relying on somebody else because we have physical ailments, or that we have some period of time where we're not able to manage our own affairs. and make all of the decisions for ourselves, including financial decisions. And so it's very important. But further important is, well, how do we make sure that we're going to be able to pay for these things? So a lot of times this comes about when somebody has dementia or memory issues or Alzheimer's, they have a stroke, they have Parkinson's, any of the dreaded diseases, so to speak. Well, it gets to the point where we need 24-hour care often. And how are we going to pay for that 24-hour care? Well, there's different programs that are out there. Most of them are programs where they say that you have to be poor. You have to spend all your money first. Well, as with any government program, if you know how the law works, you can protect yourself. You can put yourself in a better position. You can protect assets. You can take deductions on your tax return, right? So we know about this, that rich people are doing this all the time. Rich folks will have large incomes and pay very little taxes. What are they doing? Well, if you, in theory, you say, okay, well, if you're rich, you're supposed to be paying 40% in taxes. But we know lots of rich folks that don't pay 40% in taxes, right? They're applying the law as it's written in their favor to pay less taxes. They're taking deductions. They're have credit shelters, they're tax shelters, things like that. Well, I don't typically do that much with regard to taxes. What we're doing it is with regard to these other government programs that could help pay for care, that could help pay for home care, that could help pay for independent living, nursing home care, okay? This is really important because it can get so expensive if somebody has Alzheimer's. They might need 10 years worth of care. Well, that could cost $1 million for 10 years worth of care, probably more than that, honestly. And so if we have these long-term care needs and none of us know which ones of us will need that, there's ways to set up your estate plan in such a way to protect those assets and qualify for these benefits. And so this is an important thing as part of your estate plan too. So this is one of those 5 reasons why people don't think they need an estate plan, but they totally do. And the final one, and this is particularly interesting because people they think the opposite is true, and that's if you have any retirement assets. So if you have a rollover IRA or a regular IRA, traditional IRA, if you have a Roth IRA, if you have a 401k, qualified annuity, a TSP, which is a federal program, you have anything that is as a result of retirement where it's tax favored. So the traditional IRAs and 401ks means that they put the money in and they didn't take any taxes out, or you got a tax deduction for it. But when you take the money out, you got to pay taxes on it. Or a Roth, where you paid the taxes before you put it in the Roth, but you never have to pay taxes on any income that it generates again, as long as it's in the Roth. Well, we want to make sure that, when you die, that you're passing that on properly. And there's always been some complicated rules with regard to, well, how do we pay the taxes, or how do we continue to get the benefits of the Roth after we die, to have it go on to our spouse and have it go on to our kids. It's always been complicated, but it's got even a little bit more complicated, or a little bit more detailed as it relates to the new law they call the Secure Act. And so under the Secure Act, which just passed in December of 2019 and took effect January 1st of 2020, it really makes it more important that we do proper estate planning with regard to these accounts. I'm still hearing financial advisors and lawyers and others just say, just bypass your estate plan. Just use beneficiary designations for those accounts. With the Secure Act, I think that's actually the wrong answer. I think you're going to end up paying more taxes because you're not taking advantage of all of the options under the Secure Act. And the main reason is because you cannot predict who your beneficiary is. Why can you not predict who your beneficiary is? Well, the answer is because you're not dead yet. We don't know until you die, we don't know who your beneficiary is. We don't know how much money there is. We don't know what types of account it is. We don't even know what the law is going to be at that time. We don't know whether or not your beneficiary, who you think it would be, would want to maybe pass that on to their children and pay a lower tax bracket. Because with these types of accounts, the taxes are going to be based on the individual's tax bracket, not yours, but the individual that you leave behind, your child, your daughter, your son. And your daughter or son may say, I don't want to pay the taxes on this at my tax bracket. I'd rather have my kids, the grandkids, pay it on their tax bracket. Well, if we don't set this up properly, that's going to be much more complicated. Plus the idea that there are some provisions in the Secure Act which makes it so that we could stretch out those payments over a much longer period of time depending on the beneficiary. Well, I can guarantee you, if you have a trust, those are not in your trust unless you've just recently made those changes, okay? Just like in July, August, September made those changes of 2020, because those provisions didn't exist before. Those options under the Secure Act didn't exist before. So often, it's especially now under this new law, the Secure Act, it's not going to be the best answer to list the kids as beneficiaries on the IRA or on the Roth. The best answer is to have it go through the trust, but then you're going to have to update your trust to comply with this new Secure Act. And it's going to give options. Often it's going to result in less taxes and more tax savings, more tax benefits to your kids, grandkids, and beyond. Okay, so people don't think about the retirement assets. Many people for years and years, and even I'm still talking to financial advisors, even recently, that say, oh, well, we're just going to bypass the trust altogether. That's what I was taught in financial advisor school. That's what I was always taught. Yes, but it's a new world now as of January 1st, 2020, because of this new Secure Act. And so often that was the best answer. I think it's clearly not the best answer for most families. Now, if you got $10,000 total in IRAs or Roths or 401k, then it's not enough money that we have to worry about. That can get, taxed and we'll be fine. However, if you have a substantial amount, 100,000, 200,000, so on, more than that, then it's really important that we plan for that, because a small difference, a small change, being able to pay the taxes over 10 years versus 5 years, or even more than 10 years, could often save tens of thousands, if not hundreds of thousands of dollars in taxes. I was looking at one today, which was that we were talking to the clients about coming in and updating their documents. And my estimate was, if they didn't update their document, it probably could have been over $100,000 in additional taxes that they would have had to pay, because their particular beneficiary was one that would allow them to stretch it out even more than 10 years. So they, if they hadn't updated it, it probably would have been cashed in and the taxes would have been paid over a shorter period of time. The longer we have to pay the taxes, often the better it is, the less taxes we pay, the lower tax bracket that we stay in, and things like that. So not always the most obvious, but if you have retirement accounts, especially if you have any decent amount, 100,000 or more in retirement accounts, it really probably does require very specific planning with regard to this. And I understand not all lawyers are doing this. A lot of lawyers don't get into tax law. They don't get into saying, well, how do we get the best tax advantages here for your kids and grandkids and everybody else, whoever you leave behind, charities, things like that. But I think it's important. I think most people would think it's important. Most people would prefer to have more of their money, more of their hard-earned savings and retirement accounts passed on to their family and less to Uncle Sam, or passed on to a charity and less to Uncle Sam. So just be aware of that. That requires unique and specific planning. So that is the 5. And so we kind of kept it pretty straightforward today. We're going to see if anyone has any questions. And if you have a question, you might want to type that in right now. There's a little question box there. And so, Savannah, do you see that we have any questions?
I don't see that we have any questions. I do see that someone raised a hand at some point. So if you did have a question or you want us to follow up with you, I encourage you, again, just pop that in the chat box and we'll be able to help you there. Last call.
Yeah, I don't see the raised hand here, so otherwise I'd try to unmute them, but let's, if you can, just type it in, or yeah, just reach out to us afterwards. In fact, that's a good segue, perfect segue into, well, how do you get your questions answered on this? And Savannah's going to walk you through the process of what you should do now, and there's a way that you can do it and have a quick answer or to a quick interview with us to see if we're a good fit for you. If you have friends and family that any of those 5 categories apply to, we would love it if you would send them our way. So I'm going to have Savannah take over and kind of give you those instructions.
Yeah, awesome. Thank you, Bob. So as Bob said, we do have a really easy way for you to connect with our team. and go ahead and schedule a time with our attorneys. But the first step before you talk to an attorney is just to make sure that we're the best fit for you. Make sure that you like our law firm, that you like the way we do things and our team. And then we also want to make sure that we're the right law firm for your needs. So to do that, we've got a really easy process. And what you'll do is actually check your email. In about 10 minutes, you'll get an email that will be coming to you. And it will have a button. You'll click the button and it'll take you to a calendar. You'll choose a day and a time on the calendar that works for you, where our team is going to give you a call. There's no cost for this phone call. There's no obligation to move forward or anything like that. It's a free chance for you to just introduce yourself to our team and let us introduce ourselves to you. So that call should last about 15 minutes, maybe less, and it'll give you a chance to discuss your concerns. We'll determine, A, if we're the right attorney for you, and B, which one of our attorneys you should meet with, because we have 3 and each one kind of does their own thing. So we'll make sure that you're meeting with the best one. And then again, like I said, make sure that you actually like us. So check your email in about 10 minutes. That will be there for you. And then you can always give us a call. If you don't want to wait for the email, if you're just ready and you want to talk to somebody now, you can always give us a call. That phone number is 810-694-9000. And I'll go ahead and put it in the chat as well, just so you have it there. So again, that's 810-694-9000. So if you don't want to wait for the email, go ahead and just give us a call. We're here and we're more than happy to answer any of your questions. Thanks again for everyone for joining today. We're always so happy to have you, and we look forward to next week.